The Legal Practice Council has initiated proceedings that have former Public Protector Advocate Busisiwe Mkhwebane struck from the role of advocate. This action follows impeachment in September 2023, which was removed from office due to findings of misconduct and incompetence. The Council's decision underscores its commitment to upholding the integrity and ethical standards of the legal profession. For more on this conversation, we're joined by Director of the Legal Practice Council in Gauteng, Ignatius Briel. Ignatius, appreciate your time this afternoon. Now, elaborate for us on the specific factors that have led the LPC to pursuing the striking off of Advocate Mkhwebane from the role.
So you will recall that the media reporting on Advocate Mkhwebane's conduct has been quite extensive, specifically with regards to the outcome of the Section 194 inquiry that was held by Parliament. And I think the evidence that was presented before Parliament and the findings reached by Parliament has some very far-reaching consequences for Advocate Mkhwebane. And I think one of the most striking things in the review application by Advocate in respect of Advocate Mkhwebane's report on the CR17 campaign, the court expressed its view to say that Advocate Mkhwebane had actually displayed a complete lack of knowledge of the appropriate legal principles. Now, for a court to make a comment like that on a legal practitioner is absolutely one of the most damning findings that one could have by a court.
So it's a little more complicated, I'd imagine, Ignatius, than, okay, can I remedy this allegations or this judgment? So is there no room for her to correct those errors if they are indeed errors?
So on that specific matter, the case was actually taken up to the Constitutional Court, and the Constitutional Court concluded with the same conclusion. But it's more than just that one matter. You will recall that the 194 inquiry dealt with several aspects. It's the lifeboat report, it's the Vrede report, it's the Reserve Bank report. And in all of these, Advocate Mkhwebane was found to be lacking the appropriate skills and competence expected of a legal practitioner. And in cases like that, the court would then very often find that the legal practitioner is no longer a fit and proper person to practice law. If Advocate Mkhwebane is struck from the role, there's always the possibility later on for her to come back to apply for readmission once she has shown that she has actually reformed and addressed the character flaws that resulted in her striking.
So how does the LPC ensure that such decisions are made impartially and uphold the principles of natural justice?
Yes, so it's very important for us to reiterate that we are free from any political interference. Our actions are based purely on the Code of Conduct and the Legal Practice Act, in terms of which the complaints are considered by independent practitioners who sit in our investigation committees. In this specific matter, the investigation committee had actually recommended that we wait for the outcome of the parliamentary hearing. Once that had been received, we had taken the matter to our council, the National Council, which consists of 23 members who are independent members, and who then also looked at the facts that were before us. I think one of the telling factors is that when it was initially brought to the National Council last year, the National Council had actually said, let's give Advocate Mkhwebane a further opportunity to respond and give her version of the events. We had addressed at least 2 letters to her 2 weeks ago. She had failed to respond, and we've got very little choice now but to go to court.
So if she had responded, what options would have been available to her in her defense, I suppose?
It would have depended on the nature of her response. Obviously, her response would have been provided to the National Council to then also consider. But again, I think the seriousness of the allegations in the 194 inquiry would have eventually led to us bringing the matter before court. I think an important factor to remember is that the LPC is not the body who actually strikes or suspends legal practitioners. It's only the court who can do that. And for that reason, it's important for us when instances like this happen that we take the evidence to court, and the court can make an objective ruling.
Ignatius, when we consider Mkhwebane's role as a member of parliament, does the LPC in any way can take into account potential implications of its decisions?
I think when you talk about the implications of the decisions, again, it comes to the independence of the LPC. So whatever process we follow needs to be without fear or favor. We cannot be, intimidated by the fact that somebody is a member of parliament or holds a certain position. We have an obligation towards the public at large, as well as to the profession, where there's potential misconduct, that we take that misconduct to the court for the court to make a ruling on it.
Now, what precedent does this action set for other legal practitioners who may face similar allegations of misconduct?
I think this is just one of many instances where we take practitioners to court for the court to make a finding. And again, you will recall that there are several instances of high-profile matters where the LPC has actually approached the court to consider the matter. And I think what I want the practitioners out there to understand is that as much as we have no direct interest in whether you are struck or not, it remains our obligation, and we will always take the matter to court for the court to consider the outcome.
And final thoughts on how the LPC balances its regulatory responsibilities with the rights of practitioners to fair representation and due process. So if you just give us your final remarks on that, please, Ignatius.
So that's very critical, and I think, we try our best to act fairly towards both parties, both the complainant as well as the practitioner. And again, that's why you have independent members of the disciplinary and investigation committees who actually consider these complaints that come in. And both parties have an opportunity to put their version of events before the committees.